Hello everyone, good morning and welcome to today's session. Today's session will be on UK and Dutch immigration considerations for after Brexit. My name is Ellie, I'm a paralegal at Hudson McKenzie and I will be moderating today's session. So this webinar is hosted by Hudson McKenzie and Box Expat Solutions. Let me introduce our presenters and speakers. So our first speaker is Rahul Batra, who is the managing partner at Hudson McKenzie, and he will be advising on immigration issues for after Brexit, but from a UK perspective. He's a specialist immigration advisor, and he'll be more than happy to take your questions at the end during our live Q&A once the webinar has concluded. Our second and third speakers are from Box Expat Solutions, and they are Juliana van Gulik, who's a senior immigration consultant, and Paul Henderson, who is also an immigration consultant there. If anyone has any questions, please feel free to drop them in the chat box and we will be delighted to discuss them at the end. And if we don't have time, as obviously we have time constraints at the moment, if we don't have time to answer your questions, then please feel free to use our contact details, which will be used in the presentation to message us privately, and we will do our best to help you answer them. So to start off with, I'd like to introduce Rahul to start speaking on the UK's perspective on immigration for after Brexit. I will just share our slides now and then he will begin presenting. Right, can everyone see my screen clearly?
Yep. Good morning, everyone. Welcome to today's webinar, which we are co-hosting alongside Box, our friends from Box. I'm very pleased to be able to talk about UK immigration issues which will crop up after Brexit, supposedly when that happens from 1st of January onwards. And Ellie, can I have the next slide, please? So today's agenda is about forward planning, what companies should be doing to think forward and plan their way, because we will talk about sponsor licenses down the line. So that's something to take special note of. And then we also talk about the changes to the UK immigration system. We are going to see a vast change to the UK immigration system in a generation. And again, it's worth noting all these changes because you will see some sweeping tier 2 changes which will totally affect the way you send people to the UK going forward. Then we talk about the pre-settle status and settle status for EU nationals, which is a very hot topic right now. Obviously, EU nationals won't be classed as EU nationals anymore after Brexit, so they need to apply for work permits going forward. Then we talk about the sponsor licenses, the tier 2 visas, Helst Visa, which is again a very hot topic right now. And then we just give some takeaway points from today's webinar. Ellie, can I?
Yeah.
So, as I said earlier, the new points-based system is being launched from January 2021. It obviously applies to all the EU citizens because they won't be classed as residents anymore. Companies should consider applying for a sponsor license, and then you should also consider the COVID-19 issues. Obviously, the visa application centers are closed or working at very reduced hours. So there could be delays in processing time. So that's something to consider going forward as well, because we don't know what's the situation with COVID right now. And every day we see something new. So today Boris Johnson is addressing the nation and possibly talking of a second lockdown in the UK. Then the other thing to consider is the visa fees. So at the moment, EU nationals can come and work in the UK being EU nationals, and they only pay £65. That's the fee they have to pay. But suddenly you'll have to pay a very high fee and the immigration health surcharge. IHS stands for immigration health surcharge. So you're talking about thousands of pounds in visa fees, skills charge, and health surcharges. So that's something to consider and budget for when you're sending an employee, and especially if you have an employee with a family of 3 or 4. You're talking about 20,000 to 30,000 pounds just in visa fees alone. So the free movement will end from 1st of Jan 2021. Then we are looking at the restricted quota, which is for tier 2 applications. That is being removed altogether from the new year. And what that means is that you don't have to apply for restricted COS in the first instance. You can bring as many people as you'd like, because at the moment you've got 18,600 people which could come in under tier 2 general from overseas, and that's obviously being done away with now. Another major change to the UK immigration system is that they're dropping the RQF level to level 3 from the existing level 6. And what that means is that you could potentially bring in people with a lower level of qualification to the UK. So at the moment, you can only bring in level 6 people, which means managerial jobs or people with highly skilled jobs. Level 3, you could potentially bring in like an admin person alongside a CEO, maybe a secretary alongside a CEO who can come and work on a work permit in the UK. So that opens a lot of doors for people to come over. Then we have the cooling off period, which is when you are on a tier 2 visa, you have to, when you leave the country, you cannot come back to the UK for up to 1 year on a tier 2 visa. That's being adjusted and becoming more flexible for shorter term assignments. And that's short-term assignments will potentially become exempt for the cooling off period. One massive change to tier 2 visas is the resident labor market test is being done away with altogether. And what that means in layman terms is there's no advertisement required when you bring people on tier 2 general visas. And that's going to be a welcome news for employers, because that used to be a bit of a headache and a bit of a long-winded process where you have to advertise the post for 28 days and prove that you couldn't find somebody in the UK who could do the job. Then there are talks about bringing the tier 1 general route back in operation. The date hasn't been announced just as yet. We're looking at potentially mid next year. This is similar to the tier 1 general, which used to be for highly skilled workers back in the day. And it's going to be a points-based system, which is obviously unsponsored, and you can get those, obtain those points and come to the UK on a self-sponsored visa. Then we have the global talent visa, which has been introduced, which replaces the tier 1 exceptional talent visa. Then we have the graduate route, which is again being released sometime mid next year. That is similar to the tier 1 post-study visa, which was in operation a few years ago. And what that means is that if you come and study in the UK, you're allowed to work for up to 2 years. We also have the new health and care visa, which I won't go in detail because that may not be relevant for this particular webinar. But if you have any questions, you can always ask at the end. So coming to EU nationals in the UK, anybody who comes to the UK before 31st of December 2020 will be allowed to live and work in the UK, and they should be getting either a pre-settled status or settled status. What that means is that it lets you work, study, be self-employed or be self-sufficient in the UK. You can also avail NHS and you can travel in and out of the UK. To give a bit more context to pre-settled status, it is when you come to the UK initially, you apply for this status, and all that it does is it confirms your right to live and work in the UK for up to 5 years. And as I said earlier, you must have started living in the UK by 31st December 2020. And after that date, you will have to apply under a different scheme, which the details haven't been announced just as yet. And then we have settled status. Anybody who's lived in the UK for up to 5 years can apply for settled status, which is basically permanent residence in the UK, and then subsequently apply for citizenship after 1 more year. A bit more detail about sponsor licensing. So the new points-based system kicks in from 1st of Jan 2021. What we are recommending companies is to apply for a sponsor license if they're recruiting from overseas. So at the moment, if you've got employees coming from non-EU countries, you need a sponsor license, but now you'll need a sponsor license if you're hiring from EU countries as well. So we are recommending that companies pull their act together, get the sponsor license, and be prepared for it coming from 1st of Jan 2021. The home of, Ellie, can I have the slide? I haven't finished that.
Sorry.
Ellie, can I have the previous slide, please?
Yes.
The Home Office are accepting electronic documents and digital signatures for documents and submission sheets, which is a very good news. And there's potentially an indication that it will continue in the new year. And what the Home Office also announced is that they're going to start a priority service for the sponsor license applications, which is welcome news as well, because normally it takes about 8 weeks to get a sponsor license, and this will reduce the processing times tremendously. Then we also hear about a streamlined process for sponsor license renewals. We haven't got full news just as yet on this, but as in we have more details, we'll announce them through our website and potentially do a second webinar on this topic. Ellie, can I have the next slide, please? So a bit more detail about the, excuse me, about Tier 2 General Visa. The minimum annual salary is being reduced to 25,600, which is 20,480 for a new entrant. And this is, again, a welcome change from the existing £30,000 salary. But at the same time, you must bear in mind that the salary must be in line with the SOC codes. As I discussed earlier, the job level, the RQF level is being dropped to level 3 from level 6 from 1st of Jan 2021. The restricted quota is being removed. The advertisement requirement, again, is being dropped. You still have to meet the English language and maintenance requirements. One welcome change is that you have a tradable system for 70 points. So you could potentially exchange 70 points for different subcategories to make sure you meet that criteria. Then this visa still leads to permanent residence and British citizenship after 5 and 6 years respectively. Ellie, can I have the next slide? Then we have the Tier 2 ICT Visa, which is the temporary transfer of skilled employees to the UK branch. You're normally allowed 5 years in the UK on this visa, but if your salary is over £120,000, you could stay in the UK for up to 9 years. You don't have to meet the English language requirement for this visa, but you still must meet the maintenance requirement. One of the requirements for an ICT visa is that you must have worked overseas in the same business for at least 12 months. And one drawback of this visa is it doesn't lead to permanent residence or British citizenship down the line. What we are going to potentially see is that this visa will die its own slow death, because if the advertisement requirement is done away with and the minimum salary threshold for Tier 2 General is lower than a Tier 2 ICT visa, which is currently 41,500, then I wouldn't see any sense for employers to apply for ICT visas for their employees. But again, that remains to be seen, and we don't have further details just as yet. But that's something we are envisaging and what we could potentially see in the new year. We have the Vander-Elst visa, which is the Vander-Elst judgment of the ECJ, which confirms that anybody who works in an EU country, a non-EEA national, is allowed to provide services in another country without getting a work permit, although they must get an entry clearance, which is visa, before coming to the UK. And normally such visas are granted free of charge. So at the moment, there's no information from the Home Office about this visa application being dropped. So I would recommend employers to still send people on Vander-Elst visas where possible until we have further notification from the Home Office. Ellie can have the next. So the requirements for a Vander-Elst visa is that the individual must be lawfully resident in the EU member state in which the employer is established. They must be habitually employed. There's no definition of habitually employed, but what the Home Office normally considers is that if somebody's worked for at least 3 months with an employer, that would be taken as habitually employed. They must not take any other employment whilst in the UK, and they must intend to leave the UK at the end of the period for which the services are being provided. Then a few takeaway points from this presentation. As I said earlier, freedom of movement will continue during the transition period, and each EU state will decide about the status of British nationals and what formalities they need to undergo. And this is all based on reciprocity. So if we see draconian measures being taken by Boris Johnson, we can expect something similar from other EU countries. But at the same time, if we see a relaxed approach, then we could potentially see better things in the new year. So everything's up in the air for discussion and negotiation right now, and we'll have a better idea in the new year. British citizens will not need a visa to travel to the EU after 31st of Jan. That is that they don't have to get a visa if they're visiting any EU country. They can travel for up to 90 days without getting a visa. But if they're working in a particular country, they will potentially have to apply for a work and residence permit. So there will be no immediate changes made to the border crossing, and citizens will be able to use passports and ID cards. And there's an indication from the Home Office that ID cards will be phased out in the new year. And citizens will also be able to use e-gates if they have a biometric passport. So that's from me, and I'm going to pass it on to Juliana, who will carry on with the Dutch immigration changes. So over to you, Juliana, and thank you very much.
I'm Paul Henderson. I'm the immigration consultant at Box Global Expat Solutions. And for our portion of the webinar, we'll be speaking about Dutch immigration in the post-Brexit world. So can we please have the next slide, please? So for our agenda, we'll also be speaking about the importance of immigration planning, permanent EU residence document as opposed to a EU long-term resident with regard to Brexit, temporary and permanent resident documents for UK nationals, recognised sponsorship, highly skilled migrants, intracorporate transferees and EU blue cards, cross-border workers and cross-border provisions of services, permanent residence and Dutch citizenship, and the impact of remote working. And also for my portion of the presentation, I'll be focusing on the transition period, and then Juliana will be speaking about the post-transition period. Next slide, please. So the first one, importance of immigration planning. So it's important to note that we're currently in the transition period, and this is going to last until the 31st of December this year. And during the transition period, there's essentially no changes for UK nationals living and working in the Netherlands. However, from the 1st of January 2021, UK nationals will be treated as third country nationals. So that means for people who want to come here and work or who want to stay here, there's going to be additional requirements for permits and for living rights. And yeah, for employers, it's going to be important to recognize there's going to be a different process for recruitment. So for both parties, it's going to be important to engage in more planning and start taking preemptive measures to ensure that there's a smooth transition. So for UK nationals, that will mean applying for the appropriate permit. For employers, that might mean already looking into becoming a recognised sponsor, which will be the main means of bringing in UK nationals post the transition period. So yeah, moving forward, it's just for businesses and for individuals to understand there's going to be a new process. And if we're not planning effectively, there could be delays in service, there could be excessive costs. And yeah, you could find that it could have a negative impact on your business and also on your employees. Next slide, please. So for UK nationals living in the Netherlands, as I said before, for the time being, during the transition period, the rights and status of UK nationals remain the same as they were prior to Brexit. After the transition period, during this transition period, UK nationals who wish to stay in the Netherlands need to apply for one of the two following documents. And it's the residence document that's been created as a provision of the withdrawal agreement. So the first one is a temporary resident document, and the second one is a permanent resident document. And I'll go into a bit more detail about both of those in just a moment. But the most important thing is to know, to be eligible for either of these documents, you need to be registered as a resident in the Netherlands by the 31st of December 2020. Next slide, please. So very quickly, I'm just going to bring up permanent EU residence documents and EU long-term residence. So one thing we find is that some people think these are the same thing, or there's a level of confusion about which one is appropriate. If you're a UK national and you've been living in the Netherlands, you may be doing so as a permanent EU resident document, and you've been entitled to this document because you're an EU citizen. As of the 1st of January 2021, you will no longer be treated as an EU citizen. So this document, if you're a UK national, will become void. So you'll need to either apply for a permanent resident document or Dutch citizenship. But keep in mind the process for citizenship can take over a year. So unless you're really in the final stages of that process right now, you need to go for a permanent resident document as a sort of a bridging document. And EU long-term resident, this is for third country nationals. So this will be more relevant post the transition period for UK nationals that move to the Netherlands after or on the 1st of January 2021, stay here for 5 years. You may be eligible to apply for this document. But for the time being, it's important to note that if you have employees or if you're a UK national, if you're on a permanent EU resident document, you need to transition to a new document. Next slide, please. The temporary and permanent resident documents for UK nationals. So under the terms of the withdrawal agreement, the Dutch government has established temporary and permanent resident documents. And if you're living in the Netherlands with one of these documents, you'll have the right to work, to study, to be self-employed, or if you have the means, to be self-sufficient. It will also allow you to travel in and out of the Netherlands without needing additional visas or permits. Next slide, please. So a temporary residence document. If you're a UK citizen and you've been living in the Netherlands for a period of less than 5 years, this is the residence document you need to apply for. And it will confirm your right to live here and to work here. It will also be available to the family members of UK nationals. So if, for example, you're a UK national, but your family members are American nationals, they will also be able to apply for this document through you. And you'll each make a separate application, but each application will be linked. In order to be eligible for this document, you need to be registered as a resident in the Netherlands by the 31st of December 2020. The document is valid for 5 years. And while you're living in the Netherlands with a temporary resident document, you're unable to claim public funds. So for example, you're not able to claim unemployment benefits. And if you attempt to, or if you do, it can result in the document becoming void. Or if you, in the future, wish to apply for citizenship or for a permanent resident document, that application may be rejected. Also, there are a limited amount of times that a person is allowed to spend outside of the Netherlands. So you need to be aware of the conditions that are attached to the document. Next slide, please. Permanent resident document. So this is for UK nationals living in the Netherlands for a continuous period of 5 years or more. And once again, this means if you have this document, you're able to work and live in the Netherlands. And it's also available to the family members of UK nationals. But I'll just say quickly, if you, for example, are a UK national and you've been living in the Netherlands for 6 years, you'll be eligible for this document. However, if your family have only been living here for 4 years, they'd need to apply for a temporary residence document. So it's dependent on each individual's amount of time in the country. This document is valid for 10 years. And it also, if you're holding this document, you do have access to most forms of social welfare with some minor exclusions. And again, there is a limited amount of time you can spend outside of the Netherlands before the document will become void. So especially from an employer's perspective, if you have UK nationals working for you at the moment, or if you're looking to bring them into the country and you're thinking that maybe you want to send them on assignments overseas, you need to take into account how much time can this person spend outside of the Netherlands without disrupting their residency. And also you need to take into account that they probably want to have some personal leave. They probably want to go home to visit family. So coming back to the first point, planning post the transition period and during the transition period is going to be really important. Next slide, please. And here I'll hand over to Juliana.
Hello. So as Paul has already mentioned, the companies might probably wish to become a recognized sponsor in the Netherlands in the post-Brexit period to be able to employ the highly skilled migrants from the UK. The recognized sponsor is a company that becomes a trusted partner of the IND, and it has certain benefits, employing the highly skilled migrants being one of the most important of them. But then also the IND does aim to decide about the applications of recognized sponsors in a short period of time. There's fewer supporting documents necessary, And also the applications and notifications might be submitted online, which makes the process even easier and more quick. So we do recommend companies to start looking into this if that might be applicable to them. Next slide, please. I would like to go very shortly through the most used options for the residence permit for highly skilled migrants in the Netherlands. The highly skilled migrant scheme as such was introduced in the Netherlands in order to attract more highly skilled workers to the Netherlands. And one of the most important criteria for these employees is that they need to have a local contract in the Netherlands for the length of minimum of 3 months. And they also need to meet certain salary criteria according to the age. These amounts of salary are gross per month, and there are certain rules that we will talk about that apply to how do you, what you can include in these salary criteria. Next slide, please. So the first, I would like to mention what might be very interesting, especially for the young professionals and graduates within the first 3 years after the graduation or finishing research. They might be eligible for a reduced salary criteria, which can be a significant advantage for the employers that would like to bring these people to the Netherlands. There are different criteria that they need to meet that I'm not going to go into details now, but if you have any questions about this or if you would like to know more, please do feel free to contact us afterwards. Next slide, please. One of the most very important things to mention about the salary criteria for highly skilled migrants as well as all other residence permits in the Netherlands is that they don't only have to meet the salary threshold, but they also need to be in line with the Dutch labor market standards. And there are certain rules that the IND is applying for what can you include. For example, some fixed reimbursements and fixed allowances that are included in your employment contract and that are transferred to the employee every month might be included also in the salary criteria. Beware that there are also things that are not allowed. For example, holiday allowance, that is a very common allowance here in the Netherlands. Also value paid in kind or uncertain pay elements. These cannot be included. So beware of that and always contact a professional to make sure that you are doing the right thing. Next slide, please. Also, what might be very interesting for the graduates and young professionals after finishing the university in the Netherlands or abroad, they might be eligible to apply for an orientation year. This is a residence permit that they need to apply for by themselves, and that will allow them to stay in the Netherlands for 1 year and to ideally look for a work as a highly skilled migrant. What is also very interesting for employers about this permit is that the persons that have had this orientation year are then eligible for a reduced salary criteria. So it's very good for starter positions. Next slide, please. Another option is an intracorporate transferee. This is an EU-wide instrument that has been introduced by the European Commission. A very important thing about this is to mention that if the person meets criteria for this residence permit, it is not possible to choose any different route. So even though sometimes it might be a little bit more complicated to apply for this, the company is then obliged to. And what are the three indicators that will always that you can always that you always have to consider when you are thinking about this is that the person is coming from abroad to live to work in the Netherlands. They are transferred within the same company. They have been with the company abroad for at least 3 months, and their contract is also staying abroad. So they are not going to get a local contract in the Netherlands. One of the interesting things about this residence permit is that there is a possibility of EU mobility. So if you need a person, for example, to transfer within several entities in more EU countries, this might be easier for this kind of a person, of the holder of this residence permit. However, be aware that not all, unfortunately, not all the EU countries have implemented this mobility instrument, and therefore it is always good to check beforehand whether this would be possible or not. Next slide, please. Also, probably all of you have already heard about the EU Blue Card. That is also an EU instrument for attracting the highly skilled workers to the European Union. In the Netherlands, this has never been a very popular residence permit because the conditions for the highly skilled migrants in the Netherlands, or for the national scheme for the highly skilled migrants, are much more favorable, and it is also easier to apply. So but in some other countries, this is very popular. One important thing to mention about this is that the person that is an EU Blue Card holder in one EU country is not automatically eligible to work or live in another EU country. So then a new EU Blue Card would have to be applied for when the person is moving. Next slide, please. After living here for more than 5 years, of course, the people can be eligible to apply for a Dutch citizenship. In case of the UK nationals, it is good to mention that also the time that they've been living in the Netherlands under the provisions of the withdrawal agreement or before registered in the Netherlands also counts towards these 5 years. What is also important is that the residence permit must be valid at the time of the naturalization ceremony. So at the time they are going to become the Dutch citizens. So maybe good to plan ahead and also be aware of this. Next slide, please. What might be then also good to consider that you might have to renounce your UK citizenship. So there are some exceptions to this, but yeah, always good to think about what are the pros and cons of this step. Let's talk about a little bit more about the short stay in the Netherlands. Next slide, please. So as we have already heard, also the UK citizens living in the Netherlands, coming to the Netherlands for a short stay, excuse me, for less than 90 days in any given period of 180 days can freely travel to the EU and the Schengen area for business or for tourism. Towards the end of 2022, the European Union plans to, or the Schengen plans to introduce the European Travel Information and Authorization System, ETIAS. That will be a sort of an ESTA application that now exists in the United States. And this will be then applicable also to the UK citizens, and they will have to register in this system when they will be planning to travel here. Next slide, please. And this new rules also will be applicable to the cross-border workers, people that are providing services cross-border or business travelers. The exact rules on cross-border commuters after the January 2021 are actually not known yet, because there are still negotiations going on between the UK and the EU. But what we already know is that the people that are already now cross-border workers between the UK and the Netherlands will have a right to apply for a cross-border worker document under the withdrawal agreement, which will allow them basically to keep more or less the same rights as they are having right now, but the exact details and conditions will be known later on. And the people that will start their cross-border work in the Netherlands after January 2021, if there are no other agreements made between the UK and the EU, will need to probably apply for a work permit, even for a shorter periods of time. So it is very important for the employers to keep this in mind and to put it into their planning, because applying for a work permit can take several weeks. The processing time by the Dutch Labour Authority is around 5 weeks. So this needs to be taken into consideration. Furthermore, there might be in some cases also still a notification necessary under the provision of the Posted Workers Directive. Even though this is intended only to the originally only to the people moving across the borders in the EU, but some countries especially are considering to make this more unified for all people coming. And yeah, basically the same conditions that apply to the cross-border workers will also apply for the business travelers. What is very important to keep in mind, that the business travelers will have only those 90 days within 180 days in the whole Schengen area probably. So this needs to be put on also into the planning, and that comprises not only of their business trips, but also of their private trips, holidays and everything. So they will need to be really cautious and count their days that they stayed in the Schengen area. And also always check the conditions when they are exempted from applying for a work permit, and when the work permit is necessary even for a short period of time. As a last point, we would like to remind everybody about the necessity to be also aware of people that are remote working. So, for example, people that are in the Netherlands and working for a company that is in the UK. It is very good for all the companies to map their remote worker population, and then keep in mind that this can have different mobility, tax, social security, payroll implications, and all these things need to be considered if they want to be compliant.
And Rahul, I think you've got some remarks.
I think just to add here, with all the remote workers, you need to take special care of short-term business visitors who travel to different locations and try to work there. Because you're allowed to go and visit a particular country, you simply can't work from that country. You need a proper work and residence permit. So simply don't assume that because you've seen on social media that you can go to a particular country to work and be there for a few months. You should seek legal advice to make sure you're on the right side of law, because if you aren't, then that could have severe ramifications for both the employee and the employer. And that could potentially put a black mark against the employer from sending employees to that particular country in the future.
And yes, I hear Juliana and Paul's contact details. So we've now just come to the end of this webinar. Please feel free to take them down should you have any queries that are unanswered during this webinar. So I'm just going to stop sharing my screen, and then we'll go to the live Q&A session. Thank you very much to our presenters today. Let me just go to the chat box, and and see everyone's questions. So from next year onwards, should companies bring staff on a tier 2 intra-company transfer visa or a tier 2 general visa from next year? I'll direct Rahul to answer this question.
I think the simple answer is that we can't say for sure. Both options will be open next year. But I would recommend bringing people on tier 2 general visa as far as possible, because that, as I said earlier, there's no resident labor market test requirement, and the salary threshold is lower as well. And the good thing is it leads to British citizenship and indefinite leave to remain at the end of five and 6th year. So it's a bonus to bring people on a general visa. But again, the ICT option will be open, so something to consider in the new year. And as and when we have more information, we'll let you know.
Perfect. And another question that we've also got is that if companies only employ EU nationals, first of all, do they need a sponsor license? And if so, when should they begin the process of applying?
So the answer is yes. You will need to have a sponsor license if you want to bring EU nationals from EU countries. And I would recommend applying right now, because you could potentially have a huge backlog with the Home Office, especially with COVID-19 issues and all the issues going around at the same time. So like they say, a stitch in time saves 9. Apply now and be ready, so you could potentially start hiring people in the new year.
Perfect. Okay, so in summary, that basically companies should start applying for their sponsor licenses now, especially in light of COVID-19 as well, as there'll be delays in visa application times. There's also closures of visa application centres. Is that right, Rahul?
That's correct. Yes, absolutely.
And I'd like to direct this next question to Paul and Juliana. So if a company is not a recognised sponsor, how does it take to obtain recognition and until a person can start working in the Netherlands? So how long does that take?
So the application for recognition to be a recognized sponsor in the Netherlands can take up to about 90 days. Like generally the IND aims to decide within 1 month after all the documents and the payments are ready. But if they have any questions or anything, this 1 month period does not apply anymore, and it can take up to 90 days. So we would actually also recommend people to start applying for this status as soon as possible. And then the application for highly skilled migrants, let's say, takes about 2 weeks, the processing time by the IND, plus some time to collect the documents and review them. So overall, you will have to take account with about 4 months.
Okay. And so another question I also have is, for a commuter to the Netherlands, so before the 1st of January of 2020, how much time can they spend outside of the Netherlands for the cross-border commuter document?
Yeah, this is something that is at this moment not known actually. The current rules for cross-border workers are that they need to basically come to the Netherlands every week, and they need to then return at least once a week. They need to return back to their home country. That's how the rule is. But how much time will this be for the UK citizens will depend on the negotiations. So we will have to wait for that.
Thank you very much, Juliana. Another question that I've got is, if an employee is completing 5 years in October 2020, can we apply for a Tier 2 General on the 1st of January 2021 without a cooling off period? Rahul,
I'm going to try and combine my answer for 2 questions. I think somebody else has asked a question about switching from a Tier 2 ICT to Tier 2 General in the new year without a cooling off period. So my simple answer is that we don't have further details of the cooling off period right now. At the moment, all we know is that they're going to relax the cooling off period. But in October, normally the Home Office releases the guidance. So we could potentially see the new guidance being released sometime next month or early November. And we'll have further details about the cooling off period. And please get in touch with us then, and we should be able to answer that question in full details for you.
Okay, and one more question from what we've got in the chat box. So can anyone switch from a tier 2 ICT to a different sponsor in the points-based immigration system from 2021?
That is, again, we don't have further details just as yet, because the Home Office, normally ICT holders have a cooling off period to finish before they can switch into another tier 2 visa. But because the Home Office has announced that there will be some relaxation there, we'll have further details very soon when the guidance is released. So we will let you know at that time.
I think so far that's all the questions that we have from what I can see in the chat box. So first of all, I just would like to thank everyone for their presentations today. And if anyone does have any questions at all, please feel free to message either Rahul, Juliana, or Paul privately using their contact details mentioned in the slides. I don't know whether I mentioned this previously, but a recorded version will be published onto Hudson McKenzie's YouTube channel. So please feel free to go onto YouTube and subscribe so you can view it there. But if anyone would like a personal copy via email, please do not hesitate to get in contact with me. My details are mentioned in all the invitations I've sent out to all the participants today. So thank you to Juliana, Paul and Rahul from Box Expat Solutions and Hudson McKenzie.